Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Gisela K. This is Grizzly True Crime. And we're back talking about the Delphi case. The Delphi debacle. That is just what it is now, like my word. You know? And I decided to go live right after a full trial day that we covered today. If you were there, then you spent most of the day with me already. Thank you for being here then as well. If you weren't, maybe you want to check out some trial coverage. If you've never watched an entire trial before, there's many you could choose from on my playlist. I would recommend it so that you know how things work in the courtroom. Because as I say now, since yesterday, I just realized, wow, a lot of people that argue that no, it's absolutely Richard Allen have probably never watched a full trial, you know? Because it's just not, what the state has just is not enough based on what we know yet, for a full trial. Like if that's it, the things people argue, that's it. Wow, the trial, no wonder it's going to be quite short. We shall see. Whispers in the wind, welcome. Welcome to all my moderators. Thank you so much for everything you do. Welcome to all my patrons, members, subscribers, and everyone. This case will make your head spin, and these documents will also, and all the shenanigans that go on. I don't know what else to call it. So, Phoenix posted this on X and said, the court is having a weird day. And they did have a very weird day. This one caught my attention of administrative event. There's an entry dated 3/14/2024 regarding an order issuing a warrant for arrest made in error. I think it was for a media person, but how do they issue an arrest warrant in error? I don't get it, you know. I just really want to bring up the documents here because there's quite a few for us to go through. So Judge Gull issued an arrest warrant and then had to make another filing to say, whoops, that was in error. Like, what? How does that even happen? Anyway, so we're going to dive into these documents today. You know what I also want to say is, when people are trying so hard to convince you, because of course, because I express some of my opinions of which I haven't tried to convince anyone of anything because I'm not convinced. I'm just saying something shady, something sus. I don't know. I don't think they have enough. But when people are then trying to convince you, like they email me and they're really trying to convince me now, that Richard Allen is the guy. Why are you trying so hard to convince people at this point? Wait for the trial. We don't have all the info. We don't know. The wise thing to do would be to say, we don't know. And then you can form your opinion. Because we don't know. We can't convince each other. We're not the judge. We're not the prosecution. We're not the defense. We don't know. All we can do is look at the stuff and report on it and say, what? Helena says, thank you so much for all your hard work. Thank you so much for your sticker. Really appreciate it. Okay, please like and share so that others know we are live right now. They might not know after the full trial day, and so that they can find us. Okay, so let's quickly look at this one. So there is a verified emergency motion for continuance. There is also Richard Allen's third Frank's notice and request for a Frank's hearing. So another request for a Frank's hearing based on this geofencing evidence that the defense says they have or found or saw. Supplement to verified emergency motion for continuance. And this one is motion for leave of court to subpoena third-party records. That's what we have so far for today. Today's date is the 14th of March. And you can see top right-hand corner when they were all filed. So I thought we might as well go live right now and talk about it because it's going to snow documents in this Delphi case. I'm pretty sure maybe tomorrow as well. You know why? Because it's the upcoming hearing on March 18th, which is Monday. And I'm just like, the defense is working so hard and the attorney representing them, which is David Hennessy. And they're just like, obviously really preparing themselves for that hearing, but they are like really clapping back. I don't know how else to say it, right? So let's see. This one was at 2 p.m. This one is at 2:23. That was at 3:47 and at 1:53. Okay, I like to put them in chronological order as much as possible. And then McClellan, the prosecutor, will probably file at like 10 p.m. because that's what he does. Okay, if you don't know anything about this case, please check out the description box, check out my playlist, because we've really discussed this case a lot, so there's lots of recaps there for you. The trial was set for October, but now it's been moved to May 13th of 2024, which is only 60 days away. 60 days until trial, and they're still busy. They being where is Judge Gull? She's not denying things right now. She's just filing false arrest warrants. That's so weird. There's so many other things to deal with, and you're filing an arrest warrant for someone you shouldn't have? That's odd. Okay. 60 days to trial. They should all just focus on that. Just prepare for the trial. Only do that, in my opinion. So, okay, let's look at this document here. We started this one. This one is 6 pages. And we're going to read all of these things. Verified emergency motion for continuance. I will zoom in for you in a moment so you can see it really nicely. Maybe that's too small, right? Okay, we got it. Okay, here we go. Comes now counsel for defense counsel and respectfully moves the court for an emergency continuance only of the March 18th, 2024 contempt hearing. In support of this, the request the counsel states, okay? We're going to read all of it. I know you guys like it when I read documents to you. And of course, this is all breaking news. It's just come out. It's snowing documents. So let's go through them. On March 1st of 2024, counsel took the deposition of First Sergeant Holman, at which time it was learned that there were recorded interviews that had not been provided to the prosecutor at counsel. It was also learned that the attachments to First Sergeant Holman's report had not been provided to the prosecutor or counsel. Mr. McClelland promised to get them. Now, if you didn't see yesterday's live stream about Delphi or the day before we had Who's Your Cold Cases on, yesterday I went through a very interesting document from the top to the bottom as well. Please go and watch that as well because it's very interesting. So, they say Mr. McClelland promised to get them. On March 11th of 2024, counsel first received the recorded interviews of Telhera. This is all about the evidence leaks, by the way, just to give you a heads up. Defense Diaries is here. Hello. Defense Diaries podcast says, hey, Grizzlies and G, and hello to you. If you guys haven't checked out Defense Diaries podcast yet, go and check them out. Lawyers, attorneys, defense attorneys, Bob Motta and his wife, Ellie, and you're going to get the legalese explanations over there. Here you're going to get me, a non-lawyer, talking about all these things and trying to unpack all this and say, what is going on here? Okay. So they said on March 11th, 2024, counsel first received the recorded interviews. Why then? Why only then? This hearing on March 18th is about this contemptuous conduct, which I don't understand why the prosecutor's going for that because this issue's already been dealt with at the Supreme Court of Indiana. But okay, McClelland's firing again. He's like, let's, say how naughty these defense attorneys are. All right. So they should have all of the stuff that they need to prepare for this hearing. But now on March 11th is when they get the recorded interviews of Telhera, Eilenfeld, Robert Fortson. That is the guy who took his own life after the leaks. Rick Snay, his channel's called Delphi After Dark. Anya Kane and Kevin Greenlee, they've got the Murder Sheet podcast together. Mark Robert Cohen, one of the leakers, and Kyra DeBrain, as well as the omitted attachments to the report. Due to the obligations, counsel was first able to listen to recorded interviews the morning of March 13th of 2034. That's yesterday. That is yesterday. And Jeanette says Bob is as pissed off as us. Thank you. Defense Diaries Podcast says, we love you, G. Likewise. And please tell us, if you're here now while I'm live, please share your opinions in the chat here. Tell us what's happening. Am I reading it right? Like, what is going on here? So they say, due to other obligations, counsel was first able to listen to the recorded interviews the morning of March 13th, like yesterday? So they've had all these interviews about the leaks and everything that got the attorneys kicked off the case for 79 days, 4 months, and they only just gave this to them. The recorded interviews contain a wealth of information that beg independent investigation of the source of various photographs that were posted on the internet and traded between people on the internet. Still think it's gross that people were trading pictures of dead teenagers. Like, why? Why did this become a thing? Why do people feel special when they have the photos? Why do people pretend that they got the photos? I don't get it. Like, it's really weird. So, okay, like, to make themselves more important, why? Like, just please, don't lose sight of what this case is about. Justice for the victims and their families. Anyway, so I'm going to try not to go off on too many tangents here. The recorded interviews contain this wealth of information, right? And I like that they say it begs independent investigation of the source, because they're also obviously saying if you're going to blame us for some leaks, well, we got to look into what the prosecution may have leaked over the years too. I think that's important too. If the prosecution wants to point fingers, yeah, you might have to be also looked at based on what we know so far, right? And will Judge Gull also look at the state prosecutor the way that she's been looking at the defense? You know, Louise, thank you so much. So they say, additionally, had counsel had the omitted materials prior to the first Sergeant Holman's deposition, he would have asked many, many more questions which need to be asked for proper preparation and representation. The recorded interview of Miss Eilenfeld revealed that she recognized that Libby's sweatshirt was on Abby. That is interesting. Okay. She had confirmed that she received photos from a Tyler Carpenter, and this is basically the defense spilling the tea on the leak, on lots of leaked photographs and things, right? Okay. That's right. Defense Diaries podcast. I have started quoting you saying this is the case that never sleeps, because it never does. We have to stay on it. But tomorrow there'll be another 10 documents that are just like, what? Make your head spin. So I don't know who Miss Eilenfeld is, okay, just so you guys know. I don't know everyone that's mentioned here. I know some. I know of some. So she had confirmed that she received photos from a Tyler Carpenter, and there was some connection to a screenshot from George Rye, a former law enforcement officer. This was the first counsel had heard of those people and the first time he heard anything about Miss Eilenfeld. She also confirmed that she had corresponded with Mr. McClelland. She also indicated that she had been part of a small Facebook group, Reddit group, and YouTube channel, as well as a public Discord server with private chats. She also revealed that a person known to her had hired a private investigator to follow Mr. McClelland. Oh, I think I know who that lady is. Maybe not. Anyway, sorry, I'm thinking out loud. So they said, because apparently that's not true. She also revealed that a person known to her, had hired a private investigator to follow Mr. McClelland. She also identified other persons possibly involved in the dissemination of photographs and named a Paul Mannion, which is another name counsel had never heard. Lastly, she agreed to provide screenshots to First Sergeant Holman, and they agreed to do that later. Counsel had not received any screenshots and first learned of their existence when listening to that recording. So the lady who's saying that other people paid a private investigator to follow Mr. McClelland around and all that, apparently those people are saying that's not true. That never happened. So I don't know what's going on here. But I hope that this all gets investigated. During the interview with Robert Fordson, the man who took his own life after the leaks, right? After law enforcement spoke to him. During the interview with Robert Fordson, he invoked his right to counsel more than half a dozen times. Defense Diaries podcast, if you're still here, Bob, we're going to need your help with this one. Explain this to us, because during the interview with Robert Fordson, he invoked his right to counsel more than half a dozen times. And First Sergeant Holman acknowledged that he had a Fourth Amendment right to counsel. Now, I believe that First Sergeant Holman is quoting the wrong amendment there. Is he? That's what I want to know. Is he quoting the wrong amendment to that person there or not? Okay, so he had a Fourth Amendment right to counsel, even though, there we go, that is the wrong amendment, is what the document says. But is it? Because that is so shocking. That's why I want to verify. Is it? That is just, the First Sergeant is quoting the wrong right? The amendment that he has? Oh, okay. Even though that's the wrong amendment, but continue to question him. First Sergeant Holman referenced a guy from Texas, Mark Robert, who we now know as Mark Robert Cohen, and a K. Smith, which was a name counsel had never been made aware of in preparing for the contempt proceedings. There's no indication that Miss Smith was ever interviewed by First Sergeant Holman. First Sergeant Holman told Mr. Fordson that the judge isn't very happy, and he could be charged with contempt of court. He also told him that if he didn't give a statement, that would be obstruction of justice and possibly contempt of court. When Mr. Fordson indicated to First Sergeant Holman that he was not comfortable speaking with him until he was able to seek consultation, First Sergeant Holman told him if he didn't cooperate and delete whatever he had, that if he called the judge and told her he's not willing to cooperate, I'm going to make a phone call and see if she wants to issue that order or not. Well, that just sounds like he's coercing him in some way, right? Stefan's like, 4th, 5th, what's the difference? He's just like, yeah. Defense Diaries podcast. Bob says, 100. My goodness. Not a zebra says, I guess you guys would say zebra, right? South Africa would say zebra. 4th is against illegal search and seizure. Isn't that a red flag that the sergeant is quoting the wrong amendment for him there? Oh dear. Oh my. And today the judge is issuing false arrest warrants? They sound really competent. Oh my. Okay. So they said, I'm going to make a phone call and see if she wants to issue that order or not. Okay. She probably does. She probably did. This is when First Sergeant Holman also referenced that Mr. Fortson could be charged with obstruction of justice and contempt. First Sergeant Holman then said, let me call a judge real quick and we'll go from there. He then left the room for several minutes. He then returned and told Mr. Fortson that he had talked to the prosecutor. And if he was not willing to turn over any pictures or information, basically, there would be consequences. First Sergeant Holman also said that the judge had said if they have photographs, get them and get information about where they got them. First Sergeant Holman then told Mr. Fortson his lack of cooperation was going to ruin Richard Allen's rights to a fair trial. Right, as if they care about Richard Allen's rights to a fair trial. We have not seen that demonstrated. But okay. It's going to ruin Richard Allen's rights to a fair trial and going to really mess some things up for him. Okay. Then said, doesn't bother me any because it's all bullshit in my opinion. Sergeant Holman is literally saying, doesn't bother me any because it's all bullshit in my opinion. Damn, well, there's a quote we need to revisit sometime. It's all bullshit in my opinion. What? The sharing of photographs, justice for the victim, Richard Allen's right to a fair trial, or what? First Sergeant Holman also told Mr. Fortson that this is some serious shit. Okay, sorry, I'm just reading it as it is. And that the judge is adamant that he get the photos out of circulation. Well, obviously. Mr. Fortson then confirmed that he didn't have anything like that in his possession and that there was nothing for him to delete or anything like that at all. Rick Snay was interviewed by telephone. Mr. Snay indicated he had received 4 photos from Kyra DeBrain. Mr. Snay also indicated that he had heard that other people had received photos from Mark Robert and Kay Smith. Mr. Snay indicated that he had gotten the photographs Thursday, but no date was provided in his interview. First Sergeant Holman told Mr. Snay that the judge was very adamant that if any got released by anybody, she was going to issue contempt of court. She does like to issue that, doesn't she? Contemptuous. Well, issue contempt of court. Naughty people. March 13th of 2024 was the first time counsel heard the name Kyra DeBrain. Well, that's very late for them to hear about that, when they're being blamed for all of this. Remember that. Defense Diaries podcast says Holman is ISP. Indiana State Police. I'm just clarifying because we're busy with an ISP case, but that's Idaho State Police. Okay, so in the interview with Kyra DeBrain, she indicated that her source was through Reddit from a lordless warrior who she believed was Ron something. First Sergeant Holman then asked if it could be Robert Fortson, and she indicated that sounded familiar. Well, that's vague, but okay. She never firmly identified Robert Fortson. Whether lordless warrior was Ron, someone, or Robert Fortson. Mr. Brain indicated that person had deleted an entire conversation. First Sergeant Holman told Mr. Brain that the judge was pretty upset. So weird. He keeps telling people the judge is pretty upset. I mean, are you upset? No, you said you think it's all bullshit anyway, right? Okay, so the judge is pretty upset. It's like mommy's upset. Just sounds like that. I'm sorry, but it's like mommy's very upset, okay? You're going to be in trouble. We're going to tell her. She's going to be mad. Okay. I hope you like the way I interpret things. First Sergeant Holman told Mr. Brain that the judge was pretty upset and had said if they do get shared, she was going to issue warrants for contempt of court. Counsel has been provided no information identifying Lordless Warrior as Robert Fortson. The true identity of Lordless Warrior needs to be investigated. Well, they must be crapping their pants right now. Not D.B. Cooper says, Lordless Warrior is Robert Fortson. There's really no dispute there. Okay. Please do share. Also leave me comments below afterwards. I would love to read them. I want to hear all your thoughts about all of this because I kind of have to focus over here. I glance every now and then. But yeah. Sorry, I just have to look at this one comment. Low Light Recovery says, what kind of coffee does G drink? She's been going. Well, if you're on Patreon, you know what coffee I drank today. It was fizzy. It was very interesting. A new one I've tasted in Switzerland, and it really has given me energy today. Okay, number 8. Mark Robert Cohen, in his interview, indicated his source was Robert Fordson, and that Fordson had told him to delete everything. Mr. Cohen had the impression that Mr. Fordson was an attorney. Mr. Cohen also indicated that Mr. Fordson had made a $500 donation to his daughter's Make-A-Wish fund, which First Sergeant Holman then referred to as a GoFundMe. The donation was done before and was unrelated to any conversation about or receipt of any photographs. First Sergeant Holman told Mr. Cohen that the judge had told the prosecutor, who had told him that if anybody doesn't produce these or isn't willing to delete or give it up, I like how they quoted, or give it up, she's going to issue orders for contempt of court. And whoever released them will get charged with contempt of court. Well, that isn't what Mitch Westerman was charged with. I'm just saying. Okay. Yeah, CH says, fizzy Italian coffee in a can. Yeah, that'll keep you going. Now, Anya Kane and Kevin Greenlee of the Murder Sheet podcast were interviewed together. They provided printed copies of photographs to First Sergeant Holman. They identified their source as Mark Robert, but they only had 7 photographs, while the prosecution has alleged that 9 photographs were disseminated. Ooh, we see an inconsistency. So, we are the other 2. They did reference a cursor on the photograph of a close-up of Abby's head, which is curious and belies the theory that they were photographs of photographs. Ms. Kane and Mr. Greenlee indicated the close-up of the head was to document something in her hair, which was supposed to be antlers or horns. That indicates some source other than what has been alleged. At the end of the interview, Ms. Kane and Mr. Greenlee told First Sergeant Holman that they would provide him 100 plus screenshots. Well, damn. Okay. Defense Diaries podcast says, this reads like Holman bullied Fordson to the point of terror, and we know how it ended for poor Fordson. Yes, indeed. That's what, now we're seeing some evidence of the gut feel we have, the red flags that we're already raising when it comes to Richard Allen, you know? Okay, and so they say counsel has not received and screenshots, so I guess it's like Anne Hunch. It's not received and screenshots. I think any screenshots that were provided to First Sergeant Holman. Why not? Why are they not transparent? Had these interviews been timely provided, counsel would have had many, many more questions for First Sergeant Holman during his deposition, and would have had engaged in additional investigations such as the people never before known, alternate sources of photographs, the true identity of Lordless Warrior, and more. On March 13th, yesterday, Mr. McClellan of 2024, Mr. McClellan indicated that he would try to get the screenshots if they exist, when he had time. Dude. I don't even have a comment, actually. I'm just like, come on, bro. He's just like, I'll try to get them if I have time. Okay. That is nice, but not very helpful at this point. They're like, that is nice. Oh my word, I like the way they write that. That is nice, but not very helpful at this point. Welcome, Julie. Wow. First Sergeant Holman seems to believe if there are recordings or documents or people he doesn't consider important to his theory, it and they do not need to be provided. At this point, there's no time to accomplish those tasks to fully, fairly, and competently represent defense counsel on March 18th of 2024, that he would try to get the screenshots. Lastly, undersigned counsel learnt on March 13th of 2024 that his favorite aunt had passed away. Undersigned counsel. Shame, okay. On March 12th of 2024, he does not know the service arrangements at this time. It should be noted that this request applies only to the contempt proceedings and would not cause any delay in the other hearings scheduled the same day or the trial. Okay. In Ramirez versus State, the Indiana Supreme Court on transfer reversed the denial of a continuance by this very court when counsel specifically identified the late discovery of interviews and new allegations, the effect upon counsel's theory and preparation, and what counsel needed to do further due to the late discovery. That is exactly this case. Wherefore, counsel for defense counsel respectively praised the court to continue the March 18th, 2024 contempt proceedings. Respectfully submitted, David Hennessy. So I know people that, I don't know, want to snark at the defense will be like, oh, they're trying to get out of it. Well, again, because the state is not providing them the evidence that they should, right? And say, I'll try to get it if I have enough time. Not D.B. Cooper said it's absolutely insane they would send Holman to talk to Fortson, especially by himself. Absolutely irresponsible to send someone that involved in the case to interview RF. Assign someone else. Right? I mean, that as well, and it does sound like he really threatened him, you know? And I mean, the guy took his own life. He was scared. He was scared to the point, well, I'm speculating why he took his own life, so okay, I admit I'm speculating. But after the police spoke to him, he took his own life. Allegedly. I have to still say allegedly, actually. This case, oh my goodness. Defense Diaries podcast says, there's a reason I love G and the Grizzlies. Okay, thank you so much. And you say G always speaks the truth. And you definitely, we back you up and you back us up. But definitely, it's really nice to know the legal, you know, side of things. When I look at this, I'm just like, what is going on? And then I watch your streams and I'm like, I knew it. Okay, well, this one is 17 pages. So quickly, let's look at this one. They said, supplement to verified emergency motion for continuance comes now. Counsel for defense counsel and supplements with the fact that he had a lot going on and was rushed, which led to him omitting that Mr. McClelland objects to a continuance, which he does. Of course he does. Of course McClelland does. Okay, I actually wanted to look at this one. What is this? Didn't we look at this? Wait. Motion for leave of court to subpoena third-party records. I think we looked at this one. Not? Wait. It's still from this day, 2 p.m. Anyway, we'll look at that after. Let's look at this one. As I say, there's so many documents you could pick and choose and talk about it all day. My goodness. Yeah, Engineer says, G has the non-American perspective. And I live in a neutral country now, which suits, right? Now I live in Switzerland. Okay, so I could just look at this from a neutral place as best I can. All right, so this is 9 pages. It says, State of Indiana plaintiff versus Richard Allen accused. Richard Allen's third Frank's notice and request for Frank's hearing based upon newly discovered evidence and request for findings of facts and conclusions of law upon any ruling on this request. Comes now the accused, Richard Allen, by and through counsel, and files his third Frank's notice and request for Frank's hearing based upon newly discovered evidence. In support of said motion, the accused states the following. Now, I remember what this other document is now. Yeah, that's Nicholas McClelland asking for the 4th time for Richard Allen's mental health records from the prison. I mean, the last time that he asked for the mental health records, as in the 3rd time, he had read those ex parte motions from the defense that he shouldn't have read. So then he withdrew, you know, his request for those records because he's like, whoops, because people are like, how did you have access to those documents? Well, now he's confidently asked for the 4th time now for Richard Allen's mental health records for the time that he's been housed in prison, not in jail. If someone's going to, imagine if someone's now like, no, gee, it's jail. No, literally, Richard Allen is in prison for unknown reasons and was moved for unknown reasons. Like, why is he in prison and not in jail? Waiting for his trial, just like every other defendant does or suspect. Like Adam Montgomery, like Brian Koberger, like everyone else. I mean, just look how they treated Adam Montgomery. He didn't have to be in the courtroom. And here it's like, this guy, Richard Allen, you're going to be tased. You're going to be in prison. You're going to be shackled. Okay. Oh, thank you. Defense Diaries podcast says it's basically the same Doc G, minus the ex parte reading. Okay, so that's what I was thinking. This is the 4th time he's asking for it because I'm like, didn't we read that before? Because it looks the same. He puts in the entire PCA. Yeah. And then he asks for Richard Allen's mental health records. 4th time. That's all we need to know about that one. I don't know if he's going to get it this time. Okay, let's read this one because it builds on the document we read yesterday. So if you didn't see yesterday's one, the 18-page one, you might want to go and listen to that. Lucky you can listen on 1.5 speed if you want. Well, I don't know. I speak quite fast. 1.25 would be good. So it'll give you some background for this. They said, on September 18th of 2023, the defense filed its first Frank's notice, which consisted of the famous, we know all about this one, the 136-page memorandum in support detailing 1. Certain evidence that Tony Liggett failed to include in his search warrant application. 2. Certain evidence that was detailed in his search warrant application that was false. And 3. Evidence that law enforcement had acted in an intentional manner on multiple instances, attempting to conceal evidence from the defense and failing to tell the truth under oath concerning certain evidence. Now, if you didn't know, I did like reading that 136-page document. We never read it in full on this channel. I actually made you a presentation at the time, because at the time when that 136-page Frank's memorandum was released, that very same day, the lady at the court had emailed me back to say, ooh, Judge Gull has just made that private. And I'm like, what does private mean? Is it sealed? Because now it's out there. We all have it. And she's like, it's private now. So I didn't read it. I was scared. I'm not scared anymore. If they do that again, I'll be like, as if. You can't just make it private. Is it sealed or not? Anyway, so that one. So that document is very interesting though. They said the defense incorporates the contents of its Frank's notice and memorandum into this document. On October 3rd of 2023, the defense filed its second Frank's notice detailing how the prosecution and law enforcement had attempted to conceal the identity of a Purdue professor whose testimony contradicted that of law enforcement officers Tony Liggett and Jerry Holman. We went into detail of that yesterday. This notice was provided as a supplement to the first Frank's notice in order to bolster the defense contention that the state of Indiana and law enforcement were acting intentionally and or with reckless disregard of the truth to further support the request for a Frank's hearing. I still think they should have the Frank's hearing. I don't know why Judge Gull has to deny all the hearings they want to have. I think they should still have one. Defense Diary Podcast says, can I tell you all that I love the way you spell defense? But isn't someone today in chat said, because I don't spell it like that. So someone said in Canada you spell it like that. I don't know, in the UK do they? I don't know. So they said the defense incorporates the contents of its second Frank's notice filed on October 3rd of 2023 into this document. After Frank's 1 and Frank's 2, many Franks, okay, were filed, just before the defense was kicked off the case in October of 2023, the defense received certain geofencing evidence that the defense, did not have an opportunity to fully examine, explore, or discuss with its experts. Just after the defense was reinstated on the case in January of 2024, it received certain discovery in the form of a September 22nd, 2023 report authored by Sergeant Jerry Holman, reportedly memorializing an interview that Holman had with a former Purdue professor named Jeffrey Turco. Both the geofencing evidence and Holman's September 22nd, 2023 report provide new information that supports the defense request for a Frank's hearing. I agree. Defense Diaries podcast says, UK definitely. Okay. All Injustice says, this is unreal. How is it a sergeant talks to the case judge on a constant basis? What a bunch of... I mean, it is a small world there, right? Goodness, okay. Specifically, the defense received certain geofencing evidence that at least 3 persons were in or around the crime scene at a time while the murders were taking place, according to law enforcement timelines, and none of the owners of the phones have any connection to Richard Allen. Now, if you saw my map time yesterday and what we did with Hoosier cold cases the day before, that circle is very small. 60 to 100 yards does not mean people are standing on the bridge or walking around the bridge or walking on the trails or living in the homes. It's really a small little radius. It was very specific, okay? So have a look at that if you missed it. Okay, so they say 3 persons were in or around the crime scene at a time while the murders were taking place, according to law enforcement timelines. I like how they keep specifying, according to law enforcement timelines. They're open-minded. And none of the owners of the phones have any connection to Richard Allen. This geofencing evidence would provide evidence of any of the following scenarios. Those persons walking with the phones are witnesses that would have observed the murders as they were taking place, and none of them have identified Richard Allen. Or those persons walking with the phones were witnesses who observed nothing, as the murders did not take place the afternoon of February 13th of 2023, but the victims were taken to the crime scene after the search was called off. That is a possibility. Jennifer Jarvis, thank you so much. Those persons walking with the phones were participants in the murder. So I like how they go option A, B, and C, because it could be any of that. Because what are cell phones doing in that specific tiny radius, 60 to 100 yards from where the bodies were found, right? Defense Diaries podcast says, how does law not interview these people? Yeah. Said geofencing evidence was so important to somebody involved in the investigation that they created a map and plotted the movements of these persons, including movements that show at least one of these persons was within 60 to 100 yards of the crime scene at a time while the murders would have been committed according to law enforcement timelines. The phones, once again, had no connection to Richard Allen. Furthermore, the map shows that the other two phones and the persons carrying those phones were in and around the crime scene between 12:39:54 p.m. and 5:49 p.m. on February 13th of 2017. That defense has sought out but has not been provided any documents or reports that contradict or refutes said geofencing evidence, but have not found such evidence, nor has the prosecutor provided any when defense requested reports on said geofencing. In fact, the prosecution said there's no such report, which is very concerning. Why not? Why did it take them so long to even get data from Libby's phone? Like, what is going on here? So, we're on page 3 of 9. When Tony Liggett drafted his affidavit for search warrant of Richard Allen's home, Liggett, concealed from Judge Diener the fact that at least 3 phones and the people using those phones were moving in and around the crime scene at times when the murders would have been taking place, according to law enforcement timelines, and that Richard Allen was not in any way connected to those phones. Tony Liggett should have notified Judge Diener that certain people who are not named Richard Allen nor connected to Richard Allen were moving in and around the crime scene at a time when Liggett claims the murders were being committed. And remember, that judge recused himself. He signed the paper to have Richard Allen transported to a prison from a jail and then recused himself. And then Special Judge France C. Gull was appointed. Tony Liggett should have notified Judge Diener that certain people, that the murders were being committed. 15. It is reasonable to conclude that if Tony Liggett had notified Judge Diener that certain people not named Richard Allen nor connected to Richard Allen were moving in and around the crime scene, then Judge Diener would not have signed the affidavit, especially based upon the paucity of evidence otherwise contained in the affidavit connecting Richard Allen to the murders. Well, it's quite weird that the prosecutor, if you look at everything, you just look at all the weird things, because there's so many of them in this case. You know, when the former prosecutor, Robert Ayers, retired early, McClellan took over, and then it's like, oh, this judge also recused himself, special judge assigned. Could be coincidence, but there's a lot of coincidences in this case. I think some people are just like, yeah, I'm out. Speculating. So they said here, said geofencing information, would have been provided evidence to Judge Diener that negated Richard Allen's presence at the crime scene. Liggett should have told Judge Diener that crucial, relevant, exculpatory information, which had been available since 2017, especially when Liggett's affidavit was written in October 2022, over 5 years later. Sure. Exactly right. So, additionally, Sergeant Holman's September 22nd, 2023 memorialization of his interview with Jeffrey Turco, that's that professor, once again reveals that he, Holman, attempted to deceive the reader of said report by leaving out key information and words uttered from the mouth of Turco concerning the likelihood that the sticks left behind were in fact runes, making Odinism's involvement in the murders more likely and worth investigating. Holman also failed to recite the full words of Turco concerning the plausibility that those who left the runes behind were involved in some type of human sacrifice. On September 22nd of 2023, Holman wrote a report in which he, Holman, failed to mention the word rune or any derivation thereof when memorializing the words of Turco. Runes were a big part of Turco's interview, yet Holman chose to exclude the word rune or any derivation of that word from his report. Instead, the relevant part of Holman's report was the following. Okay, so you see we're expanding on what we talked about yesterday. I asked him, Turco, to summarize his findings, and he said they were inconclusive. In his opinion, he thought the sticks were placed deliberately, but was unsure what they meant. He said that he provided some educational guesses in his report. I asked him if the Odin religion practiced ritualistic human sacrifices, and he said no. He stated that no evidence or research indicates that religion practicing human sacrifices. He told me that if someone Google searched it, okay, he told me that if someone Google searched it, they may see the Vikings were accused of human sacrifices, but he said there's no proof of it. I asked him if he ever heard of ritualistic human sacrifices around here, and he said no. He told me not even in Norway, where this type of religion is more prevalent, has he heard of any ritualistic human sacrifices. Okay. Criminally focused says he lied on oath. He should be arrested, in my opinion. Right? So they say what Holman failed to write in this report were Turco's words that more strongly detailed how Odinism was likely involved in the murders due to the likelihood that the sticks were formed into a runic script. It's a given, and how it was very plausible that human sacrifice could be a component to said murders. It's quite interesting if you listen to the Down the Hill podcast and you go back to the interviews with Robert Ives, the former prosecutor, all the things that he says about the crime scene and the signatures, and there's more than 3, and it's very weird. It's so bizarre. Like everything he says is very interesting. So if you want to, Down the Hill podcast, go way back, a couple of years back, probably like 4 or 5 years back. Go and listen to that, right? Okay, so they say, because Holman had sworn under oath in his August 10th of 2023 deposition that the sticks found at the crime scene did not represent Odinism or any type of cult worshipping or any type of group that would have conducted the crime, Holman, Depo, page 63, lines 10 to 20, it was in Holman's interest to hide the actual words of Professor Turco concerning the likelihood that the sticks were formed as runes are significantly featured in Odinism. Like, why is he hiding that? Why don't they just say, well, I don't know, the professor said it could be. Why is it like, oh no, it's definitely not? That's just very strange, especially after they lost the interviews of the 5 supposed Odinists. You know, those guys that they named. Yeah, when you lost all those interviews and then suddenly it's like, oh, we don't know. It's definitely not Odinism. It's a bit weird. So they said, Turco's words and information that Holman left out of his report include the following. Now this gets interesting. After viewing the way the sticks at the crime scene were arranged, it was a given that the pattern of sticks was someone's attempt to replicate a Germanic runic script. One of Turco's colleagues, a Harvard professor with even more expertise, agreed. Odinism is an extreme neo-pagan, neo-heathenism ideology that has right-wing, racist connotations. Okay, now, hold on there. Back that up. So when people hijack this, okay, sure. When it's white supremacists hijacking this, making it their own, and kind of replicating, it makes sense that they say they were trying to, an attempt to replicate it. Then it makes sense. They said Brad Holder and Patrick Westphal were known to be involved in extremist or racist groups. Okay, allegations. I'm just reading the document. Although he could not necessarily interpret the intended meaning of these sticks formed into runes, the stick configurations were pretty clear runic, and that he could certainly imagine that this was somebody's idea, that when you do human sacrifice, you carve runes. There are some poetic sources that would sort of support that idea that somebody might have come across. The scenario seems entirely plausible to me. Turco, taped statement, 15 to 1550. So that's a timestamp they have there of whatever video they've got there. Man, I wish we could see those, right? I wish we could read that. Danny Scale said too many things are off in this case for me to buy into this being a conspiracy. Just too much has been covered up. Right? There's just a lot. Try explaining to someone who doesn't watch any true crime. I did that. I told Mr. Grizzly all about it many times. And every time I'm like, wait, listen to this. And then this happened and that and this. It's just like, what? It's just weird. Try explaining to someone, then you'll hear how weird this case is. You know, we all in true crime, we're here, we're discussing it, but man, there's a lot of red flags in this case here. They said, furthermore, Dr. Turco discussed how runes were thought to have magical significance and would be used in incantations in rituals, and that there is a sacrificial connection in mythological poetry. Turco taped statement, and there's a timestamp. According to police reports, Brad Holder told Amber Holder that he and Patrick Westphal had a falling out over something that happened in the woods near a river during a ritual. In other words, Here is what Holman did not write in his report. Turco told me that it was a given, so I like how they write it for him, how he should have written it, right? Turco told me that it was a given that the arrangements of the sticks were part of a runic script. Investigators have learned that runes are a feature of those who practice Odinism, and those who practice Odinism are sometimes aligned with racist or extremist groups. Brad Holder's son had some type of dating relationship with one of the victims. It's just another one of those strange coincidences, right? Apparently, Brad Holder's son was dating Abby. Okay, so with one of the victims, and Brad Holder was an Odinist fascinated with runes. That is true. You can see it on his own Facebook. He does make runes, okay? Okay, so, sorry, I'm just missing all your comments there. I'm going to read it after. Let's focus here. Otherwise, you guys are also going to say, just read the document, Gisela. Okay. So they say, Turco admitted that it was entirely plausible that somebody would read something on the internet indicating that Viking religions involved human sacrifice, and that same person could have an idea that when conducting a human sacrifice, runes should be carved, and that runes have a magical significance and would be used in rituals. So if they got their Odinism education from Uncle Google, well, that's what they're trying to say. Brad Holder told his ex-wife that Brad and Patrick Westphal had a falling out in the woods near a river in February of 2017 due to something that happened at a ritual. Instead of including Turco's words detailed in the previous paragraph, Holman wrote that Turco's findings were inconclusive, and then failed to even mention the word rune even a single solitary time. If you are trying to hide Turco's actual opinion about the linkage between the stick configurations and a runic script and the entire plausible opinion that human sacrifice could be a component of the murders, then you would draft your report as Sergeant Holman did, as quoted from his report in paragraph 18 above. Why is he leaving that out? I just need to sip some water quick. If you are trying to provide an accurate accounting of Turco's opinion, then you would write it as written in paragraph 22. Due to Sergeant Holman's sworn testimony from his August 10th, 2023 deposition, Sergeant Holman had a lot at stake when he interviewed Turco. August 2023, my goodness. Ideally, in order for Holman's sworn August 10th, 2023 testimony to be true, Turco would have told Holman words to the effect of, that configuration is not runic, and therefore that arrangement does not represent Odinism or any type of cult worshipping or any type of a group that would have conducted the crime. Unfortunately for Sergeant Holman, Turco did not state words to that effect. Quite the opposite. This explains why Sergeant Holman initially attempted to hide the identity of the Purdue professor. Yes, because you have to ask yourself, why? Why did they hide the identity of the Purdue professor? Pretend for 2 months or so they didn't, no idea who he is, might never know, but meanwhile were in contact with him. See Franks 2, and then attempted to conceal Turco's actual words in Holman's September 22nd, 2023 report that it was a given that someone was trying to replicate a Germanic runic script, and that it was entirely plausible that a person believed that human sacrifices involved the use of runes. In defense counsel's experience, some lawyers simply don't listen to a tape recording of an interview, but rather rely on the veracity of police reports that memorialize that interview. In this very case, for example, Brad Holder's February 17th, 2017 videotaped statement was purportedly erased. I still think it's interesting that they spoke to and interviewed video recorded interviews that group of supposed Odinists, as in law enforcement interviewed them and then just lost. Whoops, got recorded over. That is so strange. Never mind, remember, I always say it. So in the same week, they lost the gas station footage of Kegan Kline at a Marathon gas station. That's where he said he was. He said he was at a Marathon gas station in a red Jeep while someone else was committing the murder. They lost that surveillance, and that apparently was the FBI. Lost that gas station surveillance, and in the same week, you also lost all these Odinist dudes' interviews, and you just never re-interviewed them. It's just so weird. I don't know what to think of that. So they said, only a short report memorializing that taped interview exists. Like, what was the interest in them? How did they get to think up, let's interview those guys? You know? Oh my word. Only a short report memorializing that tape interview exists. Therefore, the defense is being forced to rely entirely on the words and context the author of that interview chose to include in that report rather than the entirety of the actual words uttered by Holder. Come on, voice, you can. My voice is going a little bit. We can do it. We're on page 6 of 9. The way that Holman memorialized his interview with Turco, detailed above, should cause alarm about what law enforcement choose to include or not to include in their reports. The tape recording is the best evidence. What Brad Holder shared with investigators in his February 17th, that's 3 days after the victims' bodies were discovered. 3 days. Just think about that. Why are they interviewing those guys? From that interview. Okay, but the authors chose to leave out, even innocently not knowing what was very important at the time, could be exculpatory in nature or lead to exculpatory evidence exonerating Richard Allen. However, at this time, we are expected to simply accept that the words written by the authors of Holder's erased interview provide the full gamut of information needed to protect Richard Allen's rights. Again, Holman's memorialization of Turco's words in this case should cause grave concern to this court, as it relates to any erased videotaped interviews. Exactly. The red letter says, does no one in their law enforcement or lawyers know how to back up docs, videos, etc.? This is not the Ice Age. I know, right? They say, if no one listened to Turco's actual words spoken to Holman on that audio tape, then Holman's deceptive memorialized report would leave the reader with an entirely different perspective than what Turco's words actually revealed. As it relates to Franks, the defense is required to show what law enforcement acted intentionally when including false information in the affidavit or when omitting important information from the affidavit. It would be highly unlikely that Liggett would admit, I intentionally omitted important information from the affidavit and I also intentionally included false information in the affidavit. Also, I wrote the affidavit with a reckless disregard for the truth. If the standard to get a Franks hearing is that law enforcement must admit that they acted intentionally or recklessly, then a Franks hearing is a legal fiction, as no law enforcement officer will make such admissions. I agree. Therefore, the defense is left with providing information of times and occasions when law enforcement attempted to conceal evidence or falsify information in other contexts in the case. Franks 1 and 2 provided multiple examples of law enforcement concealing or attempting to conceal evidence, and of law enforcement not telling the truth under oath, all backed up with exhibits that support those contentions. In Section 3 of the September 18, 2023 Franks Memorandum, the defense provided irrefutable evidence that Liggett provided false information in his affidavit concerning the words that Sarah Carbar spoke face-to-face with Tony Liggett, that's one of the witnesses there that day, right? Spoke face-to-face with Tony Liggett in 2017 when describing the man that she saw on the road just before 4 p.m. Liggett told Judge Diener that the man Carbar observed was the same man that Betsy Blair observed on the Monon High Bridge approximately 2 hours earlier. The problem was that what Carbar told Liggett in 2017 concerning this man's description was not the same as Betsy Blair's description, i.e. Liggett did not tell the truth. And this was right before an election, right? Okay. Liggett then misrepresented Carbar's words so that they were consistent with, wow, that's really like, oh, you made it fit. Okay. Misrepresented Carbar's words so that they were consistent with Blair's description, and then for good measure added that Carbar observed blood on the man walking on the road when that is not what she told Liggett to his face in 2017. Liggett did not tell the truth. So apparently she said muddy, but then they added muddy and bloody. Wow. The defense, we almost there, page 7 of 9. The defense would ask the court to reread Section 3. I mean, Judge Gull admitted she hasn't even read the whole document. And here we are snarking about people that don't read the whole documents. The judge didn't even. Oh my goodness, read it. The defense would ask the court to reread Section 3 in its entirety and also to review the attached exhibits to the September 18th, 2023 Franks memo that provide the absolute proof that Liggett misrepresented Carbar's words. The defense would ask the court to reread Section 3 in its entirety and also to review the attached exhibits that provide evidence that Liggett omitted crucial information concerning Betsy Blair's description of the man that she observed from only 50 feet away on the High Bridge, the one with the poofy hair. Young guy sketch, right? Richard Allen doesn't have hair like that. He never did. He was in the National Guard. His wife said he always had a buzz cut. So who's that guy? No, that's a good question. So they say, as well as the description of a vehicle found at the CPS lot after she left the trail that does not match any of Richard Allen's vehicles. Yeah. The defense would ask the court to reread the rest of the Franks 1 and Franks 2. I mean, the defense is having to ask the court, the judge, to read the documents. I mean, the judge should want to read the documents. She doesn't want to. She admitted she didn't read that whole Franks memorandum at some point. I remember reading that with you guys. So Mary says, Gull, send it to G. She will read it. Yeah, you guys must like and share. Send it to Judge Gull. Maybe she'll watch us read it. Actually, we didn't read through the whole Franks memorandum. We should do that sometime. The defense would ask the court to reread the rest of it, right, in order to gain perspective on the many instances of law enforcement not telling the truth or attempting to conceal evidence and the truth. This third Franks notice provides additional evidence of omitted information. Now it's about the geofencing and all that as well, right? Of which Judge Diener should have been advised concerning 3 phones shown to be moving in and around the crime scene at a time when law enforcement would state the murders were being committed. This third Franks notice provides additional evidence that Sergeant Holman's sworn deposition testimony was false concerning the findings of the Purdue professor, as Turco's own words confirm in a September 19, 2023 interview. This third Franks notice provides additional evidence of law enforcement's intentionality of concealing evidence, as Sergeant Holman's September 22nd, 2023 report attempted to conceal the actual words of Jeffrey Turco. Again, Sergeant Holman had sworn under oath that Turco did not find Odinism or cults as being involved in the murders, but Turco's own words show Holman's testimony to be false. It was in Holman's best interest, therefore, to omit or water down much of Turco's own words in his report, which is exactly what Holman did. I mean, why would he do that? Why? You know, is it confirmation bias, which is not professional in this scenario? Of course not. Is it that? Is it incompetence? Is it malice? What are you hiding? Who are you protecting? Or do you just not care? I mean, he said his own quote earlier was that that's all bullshit anyway, so. Right. Is it complacency? What is it really? I really want to know. So they say, which is exactly what Holman did. The defense is asking, based upon this third Franks notice, as well as the other Franks notices, to set this matter for a Franks hearing, please grant at this time, to argue that all fruits of the search of Richard Allen's home be suppressed. Now, of course, the defense wants that. If you think of defense strategies, you know, that search warrant and what they found there, who knows what all they found. They haven't obviously told the public that. Of course, they wouldn't. Not before trial, and trial's only 60 days away. But I really think this hearing should happen, and they should televise it. We want to see. Hear them out. Additionally, the defense requested on the serious matters raised in Franks 1, 2, and 3, as well as the exhibits that back up those matters, the court issues findings of facts and conclusions of law as to how and why the court ruled in whatever manner it rules on the defense request. Wherefore, defense counsel, by counsel, respectfully request that this court set a Franks hearing and also to issue findings of fact and conclusions of law as to the reasoning for its ruling. I just think that they're shining light on the dark, shining light on what should become transparent, right? Like, what is going on here? I don't think they ever expected such a really good defense team, in my opinion. I know some people think they're absolute rubbish. I think they're a really good defense team. And if you watch trials with me, you know that's not my usual go-to, okay? We always give them the benefit of the doubt, but when in some trials, we're watching the one now, right? We get a little snarky sometimes because like, come on, man. What a low blow. What are you saying? But this, I just think they're doing a really thorough job and pointing out what appears to be cover-ups, corruption. I don't know. We'll have to wait and see. Look at the signature there. Andrew J. Baldwin also signed here. I just quickly want to go back to this one because I just want to resize it for you and read this last paragraph because it's the same but different. McClelland asking for the 4th time for mental health records because he seems to be very, very worried that the defense is going to say something about Richard Allen's mental health and he can't go to trial or something like that. So he's like trying to prepare himself. But I think they've got a lot more going for themselves than that defense at this point. What do you think? Christina, welcome. So here they say, I just want to see if it says conclusion anywhere up here. Does it? No, it's all the same there. The request is made for the purpose of preparing for trial in this matter. The state believes that Richard Allen's mental health and his physical health is going to be argued at trial. I think a lot more is going to be argued at trial than that. I really do. So don't underestimate the defense team, McClelland. I think that the judge and the state prosecutor and everybody's underestimated the defense team quite a bit. Especially now that they've got David Hennessy on board as well, representing them in these matters. The state believes that Richard Allen's mental health and his physical health is going to be argued at trial. The state believes that the mental health records and medical records of Richard Allen are relevant and would assist the state in preparing for trial. The state is not asking for an entire mental health history or the medical history of Richard Allen, but only those records for his stay at the Westville Correctional Facility and the Wabash Valley Correctional Facility from November 3rd, 2022 until present to be able to respond to the allegations made by the defense and to prepare for trial. All right. The state of Indiana is aware from prior filings that the defense objects to the subpoena. The state of Indiana has also sent them a courtesy copy. Oh, wow. A courtesy copy of this subpoena. Could you send courtesy copies of the other evidence that they're asking for, the other discovery, the screenshots, huh? Could you send courtesy copies over to them, please, of all the things that they need to prepare for the trial in 60 days? Oh, thank you. Goodness. Wherefore, the state of Indiana, by Nicholas C. McClelland, prosecuting attorney for the 74th Judicial Circuit, respectfully prays this court review the attached subpoena and then order production of said records and such other relief as is just and proper in the premises. Criminally focused, thank you so much. You said, thank you for being UG. This community or chat is the safest space. We need content creators like you. You're such an amazing role model for all of us. Oh my goodness. Thank you so much. You said, thank you for covering this with honesty and grace. Oh, thank you very much. Okay, I just want to see one more thing. Where is this other link that I had earlier? Is it this one? Yeah, let me quickly bring this over. Luke, are you watching? Okay, so Luke said, who has Gull issued an arrest warrant for? Oh yeah, this was the court was having a weird day, but where is it? Is it Hennessy? Just filed the wrong, just filed under the wrong heading. Can't make this stuff up. Filed under the wrong heading. Again, they say administrative event. Administrative entry dated 3/14/2024 regarding order issuing warrant for arrest made in error. I mean, how can you do that? Okay, there's all kinds of things happening from the YouTubers that are writing to Judge Gull. Have you seen that? My word. Wow, you've never seen such a debacle in your life. Like, this case is quite something. Suzanne, thank you so much. You said, great job, G. Thank you for all you do. I just want to find one thing quickly. I'm trying to find something. Where do they say? Yeah. It's here. Court has received. Look at this one. This is what I was trying to show you. I'm just blind. I'm looking right at it. 3/14/24. Court has received a request for recording of court proceedings by news media from Jeff. I don't know how to say his surname. Wayne, and denies the same. And then after that, it was this order issuing a warrant for arrest made in error. Now, who are they trying to arrest? What is going on there? Right? Who are you arresting? But then it was a mistake. Can you imagine filing it under the wrong heading? So you're trying to make an administrative event, but you're like, order issuing warrant for arrest. Okay, sorry, we take that back. That's not what it is. That's not what it is. You really can't make this stuff up. So that's what I have for you today. I'm sure there'll be more very soon. And let's see, there will be more because Judge Gull has to respond. I mean, to all of this, we've read probably 11 documents just in the last 2 days, 2 or 3 days. She's still got to respond to all of them. Now, we know the default is deny, 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 deny. But, of course, speedy trial was like, okay, granted, because there was no other choice. So the trial is now starting in 60 days on May 13th. Therefore, this all has to be dealt with. Tomorrow's Friday. So surely Judge Gull has to respond to these things to decide what's happening on Monday. Are they going to go ahead with that, contempt hearing? I think so. What do you guys think? I think they might. Judge Gull will be like, you will be there. And you will hear McClelland scold you like, okay. Right. It's going to go right back to bite him in the butt, I think. Anyway, so I'll keep you posted. I'm glad we could talk about all this now because there's for certain going to be more. If you like the way that I present true crime, like the way that I read you documents, things like that, please like the video, share, hashtag Delphi, hashtag Abby and Libby, hashtag justice for Abby and Libby, or Libby and Abby. Okay? Those are all great hashtags to use on social media to, categorize everything together. I really hope, it's always my fear, I really hope that Richard Allen will make it to the trial, that he's not in danger, that nothing will happen to him before. Because if it does, they'll just be like, well, it was him, case closed, we're done. So I hope that doesn't happen, because I'm kind of concerned about that, right? Okay, so thank you all for being here. Really appreciate it. Thank you, mods. Really appreciate it. Oh my goodness. We had a full trial day, and then we're here. Thank you, mods. I really, really appreciate it. If you guys want to buy the mods some coffees as well, you can on grizzlytruecrime.com. There's a page that's called support. All the ways to support the work that I do are listed there. Scroll down. There is a link to buy the mods coffees. Here at Grizzly True Crime, we like to spoil the mods every quarter by distributing evenly those coffees to them. It's almost time for that, so get your coffees in for them. And I'm sure they will appreciate it. Thank you so much. Thank you, everyone. I'll see you again very soon. I'm going to rest my voice for tomorrow's Delphi documents, aren't I? Tomorrow's trial day and Delphi documents. Okay, bye, everyone.